and so excited to have Chad here before he has to completely dive into tax season. And Chad is officially the money guy. So at the end of the day, so many things that Jordan really talked about do affect that idea of we have worked our lives to build these assets and build some version of family wealth, and what's going to happen to that when we pass. And so specifically with estate planning, and more specifically the realm of asset planning, do you feel that it's really more geared towards high net worth individuals, or in your experience, Chad, is this something that all of us are going to deal with to some extent?
Jordan kind of touched on myths, and I think there is a myth out there that estate planning is for high net worth individuals. Right now, in the United States for 2024, as an individual, if you are worth less than about $13.5 million, you don't have an estate tax problem. As a married couple, if you're worth less than $27 million, you don't have an estate tax problem. And that wipes out a lot of people. So I think people will tell you, well, maybe you don't need estate planning then, and I think that's a huge fallacy. There's so many benefits to it. I would argue that if you've worked hard for your money and you want to be a good steward of it, and you have ideas of what you would like done with it when you're not around, whether you have $100,000 or $100 million, you have a vested interest in estate planning. Like Jordan said, as long as you have the ability to make decisions, you can plan out as much as you'd like, how you'd like your assets split amongst your kids, amongst charities. There's things we can do even if you have less than $27 million to try to allow you, your children, your charities to keep a little bit more of that money and maybe give a little bit less to our government. I'm not opposed to paying taxes, but I think you all probably worked hard for your money, and if we can help you keep some of that, I think that's important. So despite those large numbers I gave you, I think regardless of how much you have, estate planning is invaluable to you. I even talk to younger people. Jordan mentioned it with kids. I did my first round of estate planning when my daughter was 2 years old. I think some of you may not have kids under 18 at home, but if you have children and grandkids, you may encourage them to even think about doing some estate planning. I think it's incredibly important when you have young children, so you can direct how your resources are used to provide for them if you're not around. So,
can I piggyback off?
Absolutely.
So Chad just said, somebody who passes away can give away 13.61, just over $13.5 million over the course of their life or at their death without paying any federal estate tax. And then if you use your spouse's unused amount, Chad had said, it's a huge number. So for 99.97% of people, they don't care about federal estate tax. Next year, 2025, that number is going to go from 13.61 to it gets adjusted by inflation, so call it 14 million, give or take. But then after 2025, on December 31st, 2025, that law expires, it sunsets, and that amount is going to drop. Now, we don't know what that amount is going to drop to, because Congress has to go fight that out. And I think depending on how November goes, one way or the other, it's going to largely dictate how that limit gets set. I've heard as low as $3 million a person. I've heard somewhere around $5 or $6 million a person. So what does that mean? Well, instead of $27, $28 million couples not dealing with estate tax, it could be a $6 million family that is all of a sudden dealing with estate tax. Now, $6 million is still an incredible amount of money. I'm not poo-pooing $6 million. But if you think of, I got life insurance, and I've got the 401k, and I've got the house, all of a sudden, some people that I deal with who don't think of themselves as wealthy, when they go through the process and they fill out the balance sheet, and they're like, I put the life insurance down there, and maybe I have a small business, or maybe all of a sudden they're like, oh man, if it does drop down that low, I don't want to pay Uncle Sam 40%, beyond that exclusion amount. So I think over the next 24 months, we're going to see a huge shift And I wasn't worried about federal estate tax to, maybe I need to at least be aware that federal estate tax might be an issue based on how that law changes.
And there are a lot of people doing things right now and in the next 2 years to prepare for when that number potentially gets reduced. And like Jordan said, a lot of things you said would be proactive. When that grandfather's out in 2 years, there's not going to be a lot you're going to be able to do even 20 months from now. This stuff takes time. So thinking about it now or in the next year, preparing for that would be prudent. But going back to, no, I don't think you have to be worth more than $27 million to benefit from estate planning. I think if you worked hard for your money and you want to be a good steward of it and see it work for generations to come, whether it's with your family or a charity that is near and dear to you, I think it's something you should be thinking about.
So Chad, Jordan talked a lot about the legal tools that, well, that too, but no, I'm just kidding.
This is kind of your subject though, so I'm okay with that.
Let's kind of move on to what are some of the financial tools that you work with on a day-to-day basis that really help people hold on to what we worked for so hard?
Sure. I see my clients that I think are the best positioned have spent some time and built a relationship with somebody like Jordan, an attorney. Hopefully they're also working with a financial advisor, somebody who they trust, somebody who's helping them manage their money. And then if I'm fortunate enough, they bring somebody like me in too, and we kind of build this triangle, if you will. And I think if you can have those three people kind of working with you, a lot of my clients have given us the freedom to speak amongst the three of us, the attorney, the financial advisor, and the accountant. Even if the client's not present, as we try to plan out things. There are a lot of things we can do for you ahead of time to try to, obviously my world is focused on tax to help mitigate some taxes, but also plan for your beneficiaries, your relatives. So I think if, like Jordan says, you don't have to be an attorney, you don't have to be an expert in it. You just have to be able to find somebody like Jordan who is. I would make the same argument about the stock market. You don't have to wake up in the morning, check the stocks, and check it every hour after that to make sure your investments are still doing okay. If you found a financial advisor who you trust, they are doing that for you. They positioned you in investments that will serve you throughout your life. The same thing on the tax side. I don't expect a single one of my clients to follow tax law. It's constantly changing. It's constantly evolving. I think they make it more and more difficult every day. In some ways, I suppose that's job security for me. But I don't expect any of my clients to be experts at that. So I look at most of you, hopefully you've reached an age in life where maybe you don't have to go to work every day. And I would hope that you can enjoy that time and not feel like you have to practice law, accounting, or financial advising. Find people you trust. There are really good people in West Michigan. They're not all great, but there are good accountants, there's good financial advisors, there's good attorneys out there. Check with your neighbors, your friends, people like Laura, Jordan, and I. Be happy to refer you to people. But if you can build that circle around you, I think you will largely be taken care of. So, and enjoy your retirement. Don't feel like you have to become an attorney or an accountant in your retirement. You shouldn't have to do that. So.
Yeah, I feel like one of the most challenging things that I encounter on a day-to-day basis with many of my seniors is when they come across a question that they simply can't answer. And I mean, I find that in my own life. It's frustrating if I am introduced to a situation, I'm like, okay, who do I know that does this? And that's been one of the greatest assets in the last few years, is being able to build up such a tribe of not just people that I trust, that I can ask those questions. And when I have a legal question, or I have a financial question, or a tax question, I have people that I can easily reach out to, that I know that are going to give me advice that will be good, trusted advice. So that is huge. So Chad, one of the things that I've encountered also with my seniors, especially as they age more, is struggling to pay monthly bills And not just because the money is not there, but simply because everything has become so automated that many of the bills no longer get printed and sent in the mail. Can any of you relate to that? It's like hard to, between the monthly bills and then medical bills and things like that. Are there some easy ways to set up a trusted person as a power of attorney in the finance department to manage this task? Or are there services out there that you recommend that anyone, you might be a senior, you might simply travel, that could take advantage of that?
Yeah, great question, and don't feel bad about being overwhelmed by that. You talk about automated bill paying. I was home last night and I got an email that came through that reminded me that today I was going to be charged $19.99 for my kid's Nintendo account. I was a bit shocked by that because one, I wasn't sure we even had a Nintendo anymore. I had to check with the kids to make sure that we had that, and then found out they really haven't used that subscription in years. So as we've gotten more automated, this has gotten a lot more challenging. I would say the most common, if I'm honest with you, I don't know of a lot of services out there. Jordan, are you aware of? I used to know somebody who did it. It was a place called Rivertown Finance. I don't know if
They still do.
Still doing
Yeah,
that.
Roxanne does it through Raymond
Yeah,
now.
she went through Raymond. Roxanne's great. She started a business that both pays bills for business owners as well as individuals who need that service. It used to be known as Rivertown Finance. She recently merged with Raymond Group, which is a larger accounting firm. And I've worked with Roxanne in the past, and she's amazing. So if that's something that interests anybody, I would certainly encourage you to check with myself or Laura.
There's another firm, Wilhow Waterway. We've got 9 names in their firm name, but all they act is as third-party fiduciaries. So they act as conservators when the family can't identify somebody. They'll act as trustee of a trust. They'll act as personal representatives. So anything that is a fiduciary role, they'll fill that. And we can, if anybody has a question, we can get in touch with them as well.
And I think Jordan hit the nail on the head, though. It's when the person can't identify somebody to do it. Whether it's Roxanne, whether it's this firm, there is a cost to that. Being in West Michigan, I would say 90% of my clients that are in this position have found a trusted family member to do it. And if you have that, your son or daughter who you raised is probably, hopefully going to be your best advocate. So certainly, if you have that trusted family member, hands down, that's the way to go. But there are services out there for a cost that will do that for you. So.
And sometimes it's just a matter of there might be multiple people in a family who might be capable of taking on these duties, but maybe they have young children, maybe they have demanding jobs, maybe they simply live across the country. There are other reasons why, just because somebody is very capable of taking on that role, where it might be very appropriate to have a third neutral party do it. Even if you've got children who are all equally capable, sometimes it's a matter of not having to pick between multiple capable people and maybe have someone else in your family feel that they've been slighted by not being picked for that role. So there are certainly different reasons for that. So we're going to jump into a little bit about, kind of mortgage and various debts. So most of us either still have or have had a mortgage during our lives. And when we pass, Chad, do any of these debts dissolve upon death, or do they simply get transferred to our surviving family members? And even worse, if there's not a spouse, who is responsible for those deaths, and what tools should be considered to be used so that we're protected from being saddled with the debt of someone else?
Yeah, another great question. Jordan and I are going to kind of share this one too. As far as probably the biggest debt most people have is their mortgage. And if you pass away with that, your mortgage is most likely secured and tied to your home. So it's going to be difficult, if not impossible, to sell that home without that mortgage getting paid off. It's entirely possible that maybe the mortgage is greater than the value of the house. If there was some balance due, then there would be a look to see if there's any other assets in the estate that might help cover that. Like I said, the mortgage is going to be generally the biggest debt out there, and that is, I mean, banks, they know what they're doing. That's why they loan it to you. They base it off of your house. It's tied to that, so generally that's going to be settled in the case of debt. Jordan, you want to speak to any other debts out there?
Yeah, so the general rule is whatever you own has to stand good for what you owe. Whatever you own stands good for what you owe. And if the personal representative distributes any of the things that you own to somebody who's other than a valid creditor, if there are valid creditors, that person can be held personally liable for the amount that they've given away to bypass a creditor. So the identification of valid creditors is an incredibly important process after somebody passes away. In all conventional mortgages and in almost all mortgages that are out there, there's this due on death clause. It's a provision in the promissory note and the mortgage that you didn't read because it was a 200 pages worth of legal documents in 8 font.
It's on page 18.
And basically it says if you are the borrower and you pass away, the balance is now due on your death because the lender underwrote you as the borrower, your credit, your income, your assets. Now, are they going to foreclose on the next day? No. To be honest, they don't. They usually give you a reasonable period of time. But the estate itself then has to either refi that loan out or it can be discharged if they sell the property. So yes, mortgage loans are going to stay with the estate after the death of the decedent, along with just about every other debt that they have. And the only thing I can think of is federally backed student loans can be discharged upon death or permanent disability determination. They can't be bankrupt, by the way. So in case anyone's talking about student loans, you can't bankrupt them, but if you die or become permanently disabled, they can be discharged. But everything else, credit card debt, personal debt, 401k debts, all of those will have to be made good in the administration process.
And once again, another reason to be proactive too, because a lot of times what we like to gift to family members, and we're allowed to do that, but the timing of those gifts can be scrutinized when you pass away if there are debts out there too. So there's an element of, depending on where you are financially, when you might start gifting some of your wealth to your kids, or charities, or grandkids, or friends. And once again, that's part of being proactive in this process and starting it sooner rather than later.
And that can be a factor also with Medicaid someday if you are somebody with less assets and plan on ever being somebody that would take advantage of Medicaid. And we will be touching upon that in next month, so just kind of a side note for that. But one of the things too that I run into very often is because I work with estate properties on a very regular basis, and in that spirit of being proactive is whoever is going to be your personal representative after you pass, make sure that they are not only aware that there is a mortgage still in a house, but who it's through and where it's documented. Because as Jordan and Chad said, just because someone passes, that mortgage still needs to be paid. And we've had multiple challenges with clients who, for whatever reason, someone passes and they don't necessarily have the money to pay that mortgage, and yet that mortgage is still due every month. And so that's an important consideration to just kind of think about, hey, what would happen? How would that be paid? Is there possibly a life insurance policy that would take care of that? And the documentation of, gosh, where do I pay it? How does that happen so that you don't have an issue that the house might get foreclosed on eventually? Okay, so one of the other things with those estate properties is we often get so many financial questions that surround these transactions. And what are some of the most common questions that you tend to get from clients who are selling the property of a loved one?
Generally, probably in my world, the most popular question I get is, well, how much taxes am I going to owe on this? And that's a fair question. A lot of times the property was bought 10, 20, 30, 50 years ago for much less than it was worth when it's being sold. And what a lot of people don't realize is that if you inherit a property, and largely if you sell that, usually within 6 months to a year of inheriting it, you're not going to pay any taxes on that. You get what's called a step up in basis. What that is, and I see this happen all the time. I had a family recently that owned a house on Lake Michigan. It's been in, yeah.
This was really important. If you're going to take a note, circle this one like 5 times.
It's called a step up in basis. I'll give you an example. I had a family recently. They owned a family cottage out in Lake Michigan. Most of the kids had moved away. The cottage has been in the family for 70, 80 years. Dad's the only person left. Mom died already. Dad can't even make it out to the cottage anymore physically. And his end of the life was near. And there was thoughts about selling this cottage. And I suspect this cottage was worth $2 or $3 million. And my recollection is they bought it for a couple $100,000, many years ago. So if they were to have sold that cottage a week before Dad died, that's a pretty substantial gain, $2 million, of which they would have paid taxes to the IRS on that. They sought the advice of an attorney, of an accountant, and we said, hey, if Dad's that close, don't sell that home right now in Lake Michigan. Wait until after he passes. On the day Dad passed away, that family received what we call a step up in basis in the value of that. Prior to his passing, that basis was the $200,000 they bought it for 50 years ago. When he passed away, that basis instantly became what it was worth on the day he passed away. And they would only have to pay tax on any amount that house appreciated from the day he passed away. So if that house was worth $2.5 million on the day he passed away, and they turned around and sold it 6 months later for $2.5 million, no tax was due. So number one question I get when people pass away and what they inherit generally is, what do I have to pay taxes on? And from a real estate standpoint, generally the answer is nothing. Now the one exception I would say to that rule is if you inherit that family cottage, you get that step up to $2.5 million and you decide, you know what, I want to hold on to this for a while. This looks like a fun place to raise my family, hang out, and you hold on to it now for another 5 years, and now it's worth $3 million. Well, now it's appreciated $500,000 in the time you owned it, and you will pay tax on that appreciation. You're not going to be stuck with the $200,000 Dad bought it for 50 years ago, but you are going to have that basis of $2.5 million when he passed away. So usually we tell people, if you sell a house, a piece of real estate within a year of the person passing, whatever you sold it for is probably about what it was worth when they pass away, no taxes. If you choose to hold on to that real estate for a little longer than a year, it may appreciate in that time between when the person passed and you sold, and there could be a small amount of taxes then.
And please never put your child on title as a way of avoiding probate. We see it every month for sure. Well, I'm just going to add, Jimmy Jr. onto the title. And then when I die, if we make it as joint tenants with rights of survivorship, then Jimmy's just going to get it. Well, by doing so, they Google quitclaim deed and they find a quitclaim deed and they deed Jimmy Jr. onto it. Well, Jimmy Jr.'s basis becomes your basis. So just like the story that Chad just told, all of a sudden Jimmy's basis is now whatever you paid for the house. And we see it so often that in attempting to avoid probate through deeding him onto the title, you may have just created a 5 or 6 figure tax liability bill because Jimmy doesn't inherit the property, doesn't get the step up in basis, but you've put him on while you were alive. We see it every single month. So if you're ever wondering, do I put my child on real estate? The answer is no.
All right, so we're going to just kind of finish that up. So, Chad, how do you work alongside somebody who has been entrusted with the role of being a personal representative, and how do CPAs like yourself really come alongside those family members when someone has passed and help educate them on the steps of what needs to be done?
Sure, great question. We're seeing more and more of that now too. I don't know when it was trust became popular, but when I got into this 25 years ago, we did very little work with trust filing. More and more people who pass away now have trusts. A lot of times the personal representatives, the trustees that are taking over for this have no formal training in it. And they reach out to people like myself and Jordan. We sit down with them. We try to explain to them some of the responsibilities they have of their jobs. A lot of them want to do some accounting for how they're using and how they're distributing their trust assets so they can show family members or other beneficiaries of that. We will help them compile that information. We will often help them read through the trust along with the attorney to make sure they are fulfilling their duties in meeting the wishes of the person who passed away. And then of course there's tax filing requirements too, and we certainly step in and help that. Very few people, if anybody, just wake up one day and say, hey, I've always wanted to file a trust return. So they're kind of their own animal. Even if you prepared your own tax return forever, it's a little bit different. So we help in that capacity too. I could probably talk a little longer on that, but I want to make sure we leave time for some questions. So.
Yeah, and just kind of reiterating that idea of, as a personal representative or a trustee, you really do have the burden of reporting how you are keeping track of things. And I think that, you as in that role do have a fiduciary duty to be able to support all the bills that you've paid on behalf of the estate, all the things that you have done, and so all the more reason to really get the expertise of someone who can walk through, hey, what are some of the things that you could potentially be questioned on if you don't handle this in the way that, you should be expected to handle it.